This ruling relates to application by the prosecution that the respondent herein be remanded at Industrial Area Medium Prison. The background of facts are that when this matter came up on 9th February 2024, the prosecution indicated that the respondent was reported to have escaped lawful custody at Muthaiga police station. The respondent was therefore not present before the court on the said date. And counsel for the respondent disputed the indication that the respondent had escaped from lawful custody and submitted that it was too early to reach a conclusion that the respondent has actually escaped from lawful custody. And this court, upon request by the prosecution, issued a warrant of arrest in respect of the respondent, and the case was allocated a mentioned date of 19th of February 2024. Counsel for the respondent were directed to file either replying affidavit or grounds of opposition to the notice of motion dated 31st of January 2024 before the said date of 19th of February 2024. Today, 14th February 2024, the respondent has been produced before this court with an indication that with an indication from the prosecution counsel that the warrant of arrest was executed today, the 14th February 2024, at 4 a.m. While the prosecution has submitted that the respondent, having escaped from lawful custody at Muthaiga police station, should be remanded in remand prison, the counsel for the respondent have submitted that the respondent should be remanded either at Muthaiga police station or at any other police station in Kenya within the jurisdiction of this court. I have considered the submissions made by counsel from both sides. The first point for determination is whether the respondent should be remanded at remand prison or at a police station. From the submissions made before the court today, the submission that the respondent escaped from lawful custody and subsequently arrested and brought before this court today has not been disputed or challenged by the defense counsel for the respondent. This court has not been informed of how the accused managed to escape at Muthaiga police station, whether he escaped on his own or was aided in some manner by anyone. The question that this court should ask itself is whether this court should, at this stage, make an order for remanding the respondent in police custody pending determination of pending applications. I have read the provisions of Section 8 of the Extradition, Contiguous and Foreign Countries Act, Chapter 76 of Laws of Kenya, and I do agree with the submission by the prosecution counsel that the same provides for remand in prison. It is noteworthy that the accused person, as correctly submitted, was remanded at Muthaiga police station pursuant to an order issued in miscellaneous criminal application number 354 of 2024, where he was the respondent. It is normal for two courts or more to make orders remanding the same person at different facilities, but no one court is bound to remand an accused person or respondent, as is the case herein, at the same facility where another court had committed the person to, because each decision is made on the basis of its own peculiar merits. The merits of the application now under consideration include the undisputed submission that the respondent escaped from police custody. Counsel for the respondent seeks that the respondent be remanded either at the same police station or any other police station, and the only reason given is the order made in miscellaneous criminal application number 354 of 2024. It is my view that, based on the circumstances of this matter, as disclosed to the court in the submissions, it would be inappropriate to remand the respondent at a police station even for his own safety. Any escape as a matter of procedure must be subject of investigation, and it would not be safe for the respondent to be remanded at a police station when part of those investigations may be police officers in whose custody the respondent was before he escaped as alleged. I find that there is no reason to justify remanding the respondent at police station, be it Muthaiga police station or any other police station. The respondent shall therefore be remanded at Nairobi Remand and Allocation Prison, located at Industrial Area in Nairobi. The prosecution also sought orders limiting access to the respondent by any other advocate except those who are in court appearing for him and no other counsel, and that any relative wishing to visit him must be accompanied by the investigating officer, and that in case he requires any medical attention, then it should be in consultation with the medical doctor attached to Industrial Area Medium Remand. The application is opposed by the Defense Counsel, and I have considered the submissions made with regard to the said orders sought by the prosecution. I have read the Persons Deprived of Liberty Act, Chapter 90, Part A of the laws of Kenya, particularly Part 2 thereof, which provide for rights of persons deprived of liberty and duties of persons in charge, and I have not seen any provision which allows this court to make the kind of orders sought by the prosecution as stated above. I am also not aware of any provision of the law which allows this court to direct officers in charge of prison facilities on how to handle visitors and with regard to who should handle medical issues arising with regard to persons held in police custody. This court must be careful to operate within its mandate, and to let those in charge of prison facilities to discharge their mandate within the confines of the law. The set of orders sought are therefore declined, as this court would be exceeding its mandate to issue the limiting orders sought. As I conclude, the matter has a mentioned date of 19th of February 2024, by which time the Defense Counsel are expected to have filed their responses. Let written submissions also be filed by then, so that further directions can be issued on the said date, and the warrant on record is endorsed. Orders accordingly.
As we seek clarification on written submission on the application itself, or the written submissions by counsel to the bail application.
What did you understand?
I'm presuming that it is the written submissions to the bail application. Because that's what we were coming for.
Yes, so you file your responses plus your submission so that I don't